fact, has not only approved the charge sheet, has actually caused to be drawn an application to detain the accused persons and therefore perpetuate violations against the Constitution without even bothering to inquire from the Inspector General of Police on whose behalf these accused persons were arrested. Why have you been holding them incommunicado for more than 24 hours? And that points to another lapse in the respect for and enforcement of the Constitution of Kenya, which I have in my remarks earlier said pose grave danger to our continued existence of the rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger, that is a danger to the common bond that I alluded to, that this court must guard against. And my lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused person. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Miss Asha Bashir, has submitted to you that he who comes to equity must come with clean hands? The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day longer? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, The law on bail and bond applications is fairly well settled, and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents.
Just a moment, just a moment.
Most obliged.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30. It's now 6:40.
You know, we sat here up to 4 in the morning.
Let me finish. So we are going to stop at this point. Whatever submissions that are remaining, because we will not finish today. Because we are at Mr. Welle, this side.
We donate our time to Mr. Omar.
I did with all the others, and the president.
And then now Mr. Riungu and his team have to respond.
You know, we can take 7 minutes in
Sorry,
response.
let me finish.
Yes, you know,
So it is
from the 6th and the 7th, I donate the time to my seniors.
So it is getting dark and we have a crowd inside the building. I know you don't work here, but there's a danger in keeping this large number of people within the court premises at night. I have tried to console Mr. Welle, but he's going on and on, so I
Your
cannot
Honor,
stop him further.
I would not want to be the one to hold this gentleman here for any longer. I am happy to take your directions on how you wish to limit my time.
What I would prefer is that if you are likely to take
I'll take the time you donate, Your Honor.
another period of more than 5 minutes, then it is better we stop at this point and we continue tomorrow.
No, I'll conclude. I'll
Mm.
conclude. Within those 5 minutes, I'm
You are sure you have covered all the areas you wanted to cover?
Your Honor, in the interest of the accused who have been held for so long, I will do less than 5. I'll limit myself. If it gets to 5, just cut it down.
Because it's taking 5. Because it's taking 5.
Yes, I will take less than. Yes. Let me just conclude the point that I was trying to make here. So, Your Honor, the compelling reasons that the DPP provides can only be gleaned from these 2 documents before you. Very briefly, Your Honor, please refer to the charge sheet as against the application before you. Review that charge sheet, the offense that the accused persons have been charged with, against the offenses for which the prosecution now seeks to hold them are diametrically different. You have been told, Your Honor, that the accused are likely to be a danger to witnesses. Your Honor, look at the charge sheet. All witnesses are police officers. They are all police officers. I will not belabor the point. You have been told that the accused persons are a danger to national security. That submission has come to you from the bar. No evidence has been adduced to back it up. But nonetheless, Your Honor, there are certain presumptions that this court cannot lose sight of. And some of those presumptions are in this constitution. The security apparatus of this country follows a very clear structure created under the constitution. It is for the DPP to demonstrate why he believes that these accused persons have the machinery or capacity to undermine why it has not been demonstrated to you why these accused persons or how these accused persons will undermine the entire fabric or structure of that apparatus as created and contemplated under the Constitution. In the interest of time, Your Honor, I'm pleading with you as demonstrated by my learned friend Mr. Okach. These are Kenyans. Unless and until they are convicted of the offenses for which they have been charged, their constitutional rights under the Bill of Rights, and particularly the presumption of innocence, persists and are not suspended by the mere fact that they are now seated on that dock. Grant them reasonable bail terms. As your learned brother, Justice Mugambi, intimated, they cannot be incarcerated because certain individuals have broken the law out there. For those reasons, Your Honor, we pray that you disallow the application and allow these accused persons to reasonable bail and terms.
Mary will take just 2 minutes. Introduce her.
And on behalf of the other accused persons, I'll take strictly 5 minutes. I'll not mention any law. My good friends have mentioned the Constitution. I'll only bring the context that brings them here.
Okay. Just one moment. Just to mention it. Yes, Mr. Omar.
Thank you. Your very first one, I'll base all my arguments on Article 27 of the Constitution. Non-discrimination. With the following 5 points. All the 7 accused people come from one political party called ODM. Secondly, Your Honor, they are members of Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
Your Honor, with all due respect.
But they'll have to have
You have your time to respond. You have your time. Wait, sit down.
Relax. I said 5 minutes, I've only 2 minutes
Don't
to go.
interrupt.
Your Honor, this affidavit has no date, that's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice that the same police officers who swore this affidavit came to court and said they were forced.
So your objection, that line with respect.
That is judicial notice of it.
The officer that default to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about on his behalf. We just pray that that last line be ignored.
You know, Your Honor, it is me who represents them when the DPP wants to charge them. I'll give you specifically to the officer who swore the affidavit for the deputy president. When that affidavit was disowned, the officer came to court and said he signed the affidavit under duress. It's specific and it's on the court record. So,
our clarity is that for purposes of today, the IO that swore this affidavit is before court. He has not spoken to Mr. Omari. Mr. Omari might have done very well in other cases, but this affidavit has not been said to have been sworn under duress. That's the only clarification I'm making. For today,
I'm giving Mr. Witty the perspective that come 2027, the same will be disowned, that it was signed under duress. For now, it will not be dissolved. So that the court, as it is, it looks at the whole political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this court that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. The political dwells outside should not be criminalized. And we urge this court to see far and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk. Okay.
Let me see it. I wanted you to see this affidavit is the same what Chunga used. Chunga was not there. I wanted to bring the contest.
Your Honor, with your very kind permission, I recognize the predicament. Yes, but
I know it's not normal to.
His Excellency, the President.
See what is happening, Your Honor, in this court.
Just give me a few minutes, I sign this.
Okay.
I have so much to do.
That's in order.
This is a political contest. The mobilization of the state. And the profiling. All these are rules. No. Watu ni wabaya sana. Wanafanya kitu and Ionekane ni vipita hivi. Angalia. Kwanza vile wanataka kutoka. Wanafanya affidavit na kwa swali la mgeni wetu. Sisi tuonekane. Yes.
Even the night changes of the name of the people.
Yes.
They changed the name.
This affidavit will be used in another case. It's wrong. It's in the Mahakamni profiling. That's the profiling I was telling you. She's illiterate. Legally illiterate. We are back to the earlier. Tunaletewa chunga tena. Yes, I wanted you to say that.
I'll address it properly when I've been after. Because that's my fault. That's my fault.
Wengine watu wamekaliwa na mawakili sana. Kuna wakili hapa hajaongea kitu ya maana. And they brought their best bet. Retweet 5 o'clock ndio kama na wasubiri na retweet.
Hayo ni mashauri yanayoendelea hapo mahakamani ambapo mbunge wa Embakasi Mashariki amefikishwa mahakamani kutokana na maandamano yanayoendelea. Kulingana na mawakili wake Ndegwa Njiru na Duncan Okach, mbunge huyo alikamatwa hapo ndege wa kimataifa wa Jomo Kenyatta akitoka Mombasa. Baadaye alipelekwa kituo cha polisi cha Wanguru ambapo alizuiliwa hadi alipohamishwa kituo cha polisi cha eneo la Nairobi. Mawakili hao walisema kuwa mbunge huyo amekuwa bila chakula kwa masaa 72 na kwamba alinyima fursa ya kupata dawa yake, na tutaendelea kukujuza kuhusu maendeleo hayo. Naam, karibu kwenye majira ya EBN. Jina langu ni Victor Enzo Belli. Na tukianza ni kuwa Rais William Ruto hii leo alizuru kaunti ya Isiolo kutoa hati miliki za ardhi, ambapo aliendelea kushambulia upinzani kuhusu maandamano ambayo anasema hayatunufaishi vyovyote. Kiongozi huyo wa taifa alisema serikali yake imejitolea kabisa katika kujenga ajira kwa vijana na mipango yake inakamilishwa na maandamano hayo. Alipongeza Wakenya kwa kutounga mkono ghasia na badala yake kuchukua njia ya amani.
Chakula haiwezi kupungua, bei, gharama ya maisha haiwezi kupungua ati kwa kufanya maandamano na kuvaa sufuria kwa kichwa. Hata uvae sufuria miaka ngapi, kabla hujaenda shambani kuzalisha chakula ni kazi bure. Kuna vile hata kwa dawa, hata kwa uganga, hata kwa uchawi, uvae sufuria sijui miaka ngapi, bei ya unga itashuka chini ati kwa sababu umeweka sufuria